All right. Good evening, everyone, and thank you so much for joining us. Before we begin, I would like to ask you all to please enter your name and the city that you reside in the chat. And I just want to start off by introducing myself. My name is Lisa Partida. I work with Home Again LA here as a case manager. Home Again LA is a nonprofit organization based out of the city of Burbank, and we work with the homeless population and households that are at risk of homelessness here in the city of Burbank and Glendale. Just to give you a little bit of information on our 5 core programs that we offer, we have a 90-day shelter for families with children, rapid rehousing for homeless families. We also provide prevention rental assistance for households that are at risk of homelessness, transitional housing, and now we also offer community workshops, which I'm happy to announce that tonight is our first workshop that we're hosting for our new program called Lifting People Up Citywide. The workshops for this month will pertain to tenant rights, and I would like to thank Elena Eden with Housing Rights Center for presenting, and tonight's presentation is about COVID-19 tenant protections and what you should know about certain issues that you or someone you know may be facing. These times have been challenging and we need to learn more about these protections because they are beneficial. So with that being said, I'll pass it on to Elena.
Hi, everyone. Thank you so much for coming. Again, my name is Ilana Eden. I am the Director of Media Outreach and Education at the Housing Rights Center. And we're partnering with Home Again LA and the Lifting People Up program in the city of Burbank to bring this workshop to you. A lot of folks I saw are in other locations throughout LA County as well. That is totally fine. We are going to be focusing, I saw a couple city of LA, so I'll try to point out any differences between LA and the rest of the county as we go. But many folks here, many of your cities are going to have, all the same information is going to apply. So let me just begin by introducing the Housing Rights Center for those who may, just be being introduced to us right now. We are actually a nonprofit that focuses on fair housing, and fair housing means access to housing without discrimination, equal access to housing, and this really came about as a result of the civil rights movement. So that's really our legacy. We were founded in 1968 to do this fair housing work, and we are still one of the largest, if not the largest, fair housing organizations in the country. We serve almost all of LA County, as well as also Ventura County. And our services are free. They are available in multiple languages that we either have someone on staff who can help in a different language, or we can also use an interpreter in the rare case that we don't have someone who can help directly. So I hope that is not a barrier for anyone. So when I talk about our free services, one of the major ones is housing counseling. And this simply means answering questions, giving information. People might get a notice and not know what to do, or receive a rent increase, or whatever it is. We can answer those questions. That classic question, can they do that? Right? We can answer that question. We can tell you maybe some options that you might have, some other resources, et cetera, to just try to empower folks to be able to stay in their housing if they wish, and live there comfortably and equitably. So I have our housing rights hotline, as I call it, on the screen. We do answer these calls live. However, we also get a lot more calls than we have staff. So please do leave a voicemail with your phone number so we can call you back. You can also email us at info@housingrightscenter.org. And our offices are currently closed, so we are just doing phone, email, Zoom, social media, wherever else you can find us, but just not in person at our office at the moment. We also investigate discrimination cases. So when our counselors hear about a case that sounds like discrimination, we elevate that and we can do more investigation, we can do more advocacy and try to find a resolution, a correction to this issue. A lot of the time, we are able to just resolve the problem through our own advocacy, but we also have a litigation team. And when we need to, we can and do go to court to protect people's housing rights. We also put out a rental listing. It's called Project Place. It comes out every month. We just released the July issue today. So if you are looking for affordable housing somewhere in LA County or Ventura County, please do check it out. You can find it on our website. You can also sign up to get it emailed to you every month. We do other forms of outreach and education as well. This workshop that we're doing tonight, you can always catch it again on our Facebook or by registering at our website. And we also do it in Spanish as well at the same time that we're here right now, 6 o'clock on Thursdays. So feel free to join any of our virtual events and workshops. We're happy to answer people's questions. So a little bit long introduction, sorry about that, but I want to get started now by talking about the eviction defenses that we have in LA County related to COVID-19. And I want to start by pointing out, I am not saying moratorium. I am not saying moratorium because, let's actually begin. So a tenant might still receive a notice from their landlord that says, I want you to move out for some reason. There is nothing that stops a landlord from serving you, the tenant, that notice, but that notice is not an eviction. Very important to understand this. If you receive a notice from your landlord, that does not mean that now you have to move out. The notice is a warning that they are intending to file an eviction in court. Eviction is a legal process. The legal name for it in California is an unlawful detainer. So if you have paperwork, that's what it might say, unlawful detainer. If the landlord does go ahead and file an eviction, an unlawful detainer, after giving a notice to you, a warning to you, right? If they do go ahead and file in court, the court will then send a notice, a summons. Do not ignore what the court says. This is very important, right? The summons is basically the first step where the court is basically saying, hello, someone has filed a case against you. Are you here? Are you going to participate? Are you going to respond? You want to respond because you want to get your chance to share your arguments against the eviction. If you ignore the court or the notice, you have a much higher chance of actually going and getting evicted at the end of this process. So if you do receive that form from the court, you have 5 business days to respond. And the response is something specific. It's a form called an answer form. And that's your first chance to tell the court, I don't think I should be evicted, and I'm going to share all my arguments, my legal defenses, why. And this is where the COVID-19 protections come in. This is where they kick in with their strength. They give you that defense that you can share in court. It's a legal defense. So it's not preemptive. It doesn't stop beforehand. It doesn't nip it in the bud, right? It comes in more toward the end of the process. So you have to make sure that you do respond and go through that process so you get that chance to use your protections. So that's why these Know Your Rights trainings are so important, in my opinion, in my somewhat biased opinion. If you do receive a notice, I'm going to share this resource again at the end. So just a little bit of foreshadowing, right? It's a great idea to get legal aid. You can get legal aid through Stay Housed LA. This is an initiative throughout the county that the Housing Rights Center and a bunch of other organizations are also part of to provide free or low cost eviction defense, legal defense. So just wanted to sort of set the stage a little bit with that explanation that, again, these protections come in the form of a defense in court. I see a question about whether I will share these slides. Absolutely, more than happy to share these slides. So if you registered, if you sent an email to register, you will receive it at that email address. All right, so now let's move into some of the important protections. So the first thing I want to address, first thing I want to address is the rent relief program, the California Rent Relief Program. You may have known it as Housing is Key. So the program is closed now. They're not taking any new applications, but we know that a lot of people are still waiting to hear back. Their application maybe is still pending or processing. So you can check your status on your own. You don't have to call the call center for that. You just have to log in. We know that the program is going to fund all eligible applications. So if you log in at housing.ca.gov or housingiskey.com, the place where you applied, the same website, if you log in there and you see that there is a request of you, a missing document, something like this, definitely do respond so that they know that you're still eligible and you have whatever it is that they need from you. So make sure to check and to respond. We also know that they are not going to award any funds for rent that was due after March 31st. So if you applied, even if you applied before, but you requested a rent for April or May or June, they're not going to fund that. They will fund anything before March 31st. Lastly, we also know that if your application and you are simply waiting for the check to be dispersed, you will have a defense in court against eviction for that unpaid rent. So if the landlord, in other words, is trying to evict, maybe serves a notice saying you have not paid your rent for March 2022, but you know, and maybe they also know, that your rent relief application for March 2022 was accepted and they're just waiting to send the check, right? Then you cannot be evicted for that rent. Does that make sense so far? Okay, I'm gonna take that as I take your silence as a yes. Great. So, feel free to type questions in the chat as we go. I'm sorry, I didn't say that earlier, but if I may save some for the end, I may try to address them in the moment, just depends what they are. And we can always come back and review things as well. All right, so first of all, right, we have our first eviction defense, which is if you do have rent relief that is just waiting to be sent to you. I saw a chat saying that this wasn't clear. Can you go over, sorry, which statement? Feel free to unmute yourself, Cynthia, if you want to ask your question.
Okay. Can you hear me?
Yes.
Oh, okay. Can you go over that last sentence of
Right here.
If the application, the last subject, but the last sentence.
Okay.
It's like,
So
okay,
I think I was just giving an example and saying, let's say that you have applied for rent relief and you log in at housing.ca.gov and it says application is approved, but the check has not been sent yet or something along those lines. At that point, the tenant has a defense against an eviction for that rent. So in other words, the state is saying,
I heard that part, but there was another after that.
I am not sure. I think that was the last bit. Yeah, just remember that, you might still receive a notice, and don't panic because that's just a warning. And you could respond to the landlord in writing and let them know, I actually have a rent relief application. I'm expecting this rent. This eviction, is not, or viable in court. I have a defense, I have a protection, and I have a sample letter for that I can send out after this as well.
Okay, great.
Yeah,
Thank you.
absolutely. All right, so one obvious next question, right, is what if I still can't pay my rent? Of course, right? Everybody's still in that situation. So here is what the LA County tenant protections have to say about this. And this applies everywhere in Los Angeles County. So the city of Burbank, the city of Inglewood, I saw represented. Did I see any others? I think those were the main ones. Pasadena as well. Yeah. There is a difference in the city of LA, which I'll explain. But first, let me explain the county protections. So between April and June 30th, there was no protection in the county for not being able to pay your rent. So if you have missed any rent during those months, April through June, that is vulnerable to eviction. Starting July 1st, starting this past Friday, tenants with lower incomes can once again start to delay the date that their rental payments are going to be due. So it's not forgiving rent or canceling rent, but it's delaying how long you have to pay it. And it's delaying for quite some time. So the payments that you can delay are for July through December. Those months, if you cannot pay that rent, you can delay the date that it's due. Any of those months, whether you delay every single month or you only delay the rent for July, however much it is, it's all going to come due December 31st, 2023. Sounds like I'm going to ask everyone to mute themselves. Thank you. And I see that one person is having an issue with the sound. Lisa, would you by any chance be able to help out Susan with that?
Yeah, let me see what's going on here.
Thank you so much. All right. So I mentioned that this was something that tenants with lower incomes, a protection that they can use. Specifically, this is for tenants who make under 80% of what's called the area median income, or the AMI. You don't have to dive into this, but I have a chart here to just show, you can see where you might fall on this scale. So it depends on how big your household is. And we have 80% of the median income, these highlighted numbers here. So for a family of 4, a household of 4, right, they would need to make at or under $64,000 a year in order to be able to delay their rental payments without being evicted. Does that make sense? All right. So the big difference for the city of Los Angeles only is that there is no income requirement in the city of LA. Any tenant who has been financially somehow impacted by the pandemic, you've lost income perhaps, probably the most common reason, can delay their rent. The other big difference for the city of LA is that there's no definite end date for how much longer you can delay rent for. They are looking at phasing it out, but they have not identified an end date yet. Once that end date does come, it will be the rent will be due 12 months after that, just like LA County is due 12 months after the end. Does this make sense? I know that it's very complicated, and there have been many changes. If you've been following them, you may be confused. But it's basically designed as a protection so that if you can't pay your rent during this emergency, you have more time later and you won't be evicted in the meantime because you didn't pay your rent for some months. Jill asked, I believe you're asking about the city of LA. Yeah, so the city of LA protection will end when they end the emergency. That's exactly right. The local declaration of emergency. Or they take some action, they declare that they're lifting it.
Thank you.
Of course. All right, so just to recap this process, right? Remember that you are going to have to pay this rent at some point. However, if you notify the landlord correctly, which I'm about to share, the landlord will not be able to evict because you didn't pay that rent. If, let's say, you delay some rent, July, August, September, and a year passes and now it's December 2023, right? And you haven't paid it back by that time, the landlord will be able to sue in small claims court. So this is different than eviction, right? It means it's basically like if you had credit card debt that you didn't pay, right? Eviction is not on the table, but there could still be consequences to having that debt. So it's just it's debt, it's not canceled rent. Secondly, this only works if you notify the landlord in writing every single month that you want to delay your rent. When you would normally be paying, when your rent is due, go ahead and give the landlord this notice instead. If you visit norent.org, norent.org, put together by many of the nonprofits in this area, they help you to fill out this notice online in English or in Spanish. We also have these forms available on our website too, housingrightscenter.org. And again, I will send them out along with the slides and everything else. So turn in that notice. And if you're in most of the county other than the city of LA, you may also need to provide a self-certification of your income. Now I say self-certification because you don't necessarily have to provide a lot of external documentation like a bank statement. You can attest yourself and just sign a statement saying that you meet the criteria. We also suggest, especially depending on your relationship with your landlord, we suggest that you document the fact that you turned this in. You don't want to be in a position later where the landlord says, I never saw that, I don't believe you. And now a year has passed and you can't agree over whether this was turned in or whether you owe the rent, right? So some people send via certified mail. Some people bring a witness with them who can attest that they turned it in. Some people film themselves. These are all good ways to do it, or options. But do document things because we are talking about a time span of at least a year, right, until December 2023, and build that record now so that you have it all in black and white. Last important point, once again, if you do get a notice from your landlord anyway, even though you told them about the protections and you told them that you meet the criteria and all of this, and they still give you a notice, right? Get legal assistance as soon as possible. Visit Stay Housed LA. You can visit the website or the phone number. It makes a big difference to have an attorney on your side. I see a question about, can you send the declaration via email? I believe if you go through norent.org, I think they do both, but I'm not 100% sure. I would suggest doing it via paper, maybe certified mail, and then maybe you could also email it as a sort of backup and say, I sent this in the mail, just providing you a digital copy as well. I think it's best to be cautious whenever you're dealing with a situation where you're not paying your full rent, because if you don't have good documentation for that, it looks like you're just simply not paying your rent, and that's a very easy reason to get evicted. So I would err on the side of caution. And Jill, you asked about the notice you have been using in the past. I'm guessing that maybe came from us or from Stay Housed. It should be fine, but again, just to err on the side of caution, maybe check out our website or norent.org and see if what you're using looks the same. Oh, I see another question. For April to June, so this period here, when there was no protection, will tenants be able to pay the landlord? Okay. So let's say that you receive a notice because there was some point between April and June where you didn't pay rent and the landlord says, I'm gonna file an eviction for that rent. If you can pay the rent, if you can respond to that and say, here's the rent, that should take care of it. So the notice that they provide is typically going to be a 3-day notice, and it's called a pay or quit notice. And I just am mentioning that because to highlight the fact that there are 2 options there, pay or quit, right? You can either pay or you have to move. So if you pay, that's an option, and that should stop the eviction. And these protections really add a 3rd option, which is you can pay, you can leave, or you can respond and say, I am protected by the COVID-19 emergency protections. That being said, we do recommend turning your notice in before you receive a notice from the landlord. Don't wait to receive a notice. You can give it as a response, but better to be proactive and give it to them as soon as your rent would normally be due. All right. Okay, so I'm going to move to talking about some other eviction protections that are in place in the county. These are also in place until the end of this year, December 31st, 2022. And they give tenants a defense if the landlord wants to evict them for, first of all, having someone staying with you who's not on the lease, an unauthorized occupant. And that also extends to pets, unauthorized pets. And it also covers nuisance. This is really about more mild nuisance issues like noise. And it's really designed to be to respond to a pandemic related situation. So maybe, for example, you've had to take in friends or family who lost work and lost their place. And maybe that person also had a dog and a baby. And as a result, your home is noisier than it used to be, right? Or perhaps the children have been home from school while the schools have been closed and the daycares have been closed, and there was extra noise during the day because of that. That's clearly pandemic related, right? So these types of situations where people have been impacted, that's what this protection is really meant to apply to. If you get, you have someone staying with you who, it's not because of COVID, it's unrelated, I would definitely talk to an attorney and to see if there's a way that you could squeeze into this protection or not, because it might depend on the situation. So that's all one big package. There's also a defense against no fault evictions, which means any eviction that is not the tenant's fault. That could be because the owner wants to demolish the property. They want to do big renovations in the property and gut the building, right? Anything along these lines, they want to sell the building, whatever it is, it's not the tenant's fault, right? The tenant has a defense in almost every no fault situation. There is one exception, and that is in some cases, the owner can evict in order to move in themselves or their family member. This still should not be most cases. It can only be 3 units or less on the property that can even be considered for the landlord to be able to do this. And another important criteria is that if the tenant is a senior, 62 or older, is disabled, terminally ill, or low income, any of those things, that tenant can only be evicted if the landlord or the family member who's going to move in is also a senior, disabled, terminally ill, or low income. So it's an extra layer of protection. Again, I don't want to necessarily get too deep into this unless people have questions about it, because it is a little, you can see all these criteria. I don't want to be confusing, but essentially this is a narrow exception. There are still going to be lots of owner move-ins that are not going to be allowed to go through, but in some cases they will be. So if that is a concern for you, if you're thinking the owner wants to move in or move in their family, or you've got a notice that says that, please do contact us and we can go through in a little more detail. And maybe if we have time and questions today, we can do it too, to see, whether this would apply in your situation. But for the most part, again, no fault evictions, tenants are protected against those. The other thing I should mention, since we do have some folks in the city of LA here, there is no exception for owner move-ins in the city of LA. City of LA simply says all no fault evictions minus emergencies, basically. Emergencies like the roof is caving in or something like this. All right. Yes, once again, absolutely, you can put questions in the chat. For the moment, I'm going to move on to some other protections. There is an extra heavy protection right now against illegal harassment. Harassment of tenants has always been a problem, but during the pandemic, it has increased so much. Tensions are high, everybody's struggling, and the conflicts are increasing and the harassment has increased too. So the county has basically put some extra penalties on harassment right now, just to make it, to try to deter it more. But first of all, what even constitutes harassment? How do you know if what you're experiencing is harassment? So there are many, many different ways that it could look and many forms that it could take. But essentially, it is any type of action that the landlord or the property manager or whoever is dealing with the housing, any type of action that they take just to be harmful to a tenant. So for example, it could mean that they took away some services or access to a facility that's included in your lease that you're supposed to have, like parking or laundry. It could be ignoring requests for repairs or just refusing to do them. It could be coming by the home excessively every week, every day, or maybe at odd hours late at night, or maybe coming in and taking pictures of your personal belongings, right? Things they don't need. It could be refusing to accept your rental payment. And I do want to flag that one. Whenever I see that a landlord is refusing to accept a payment, that tells me the landlord wants that tenant out. So if that does happen, I strongly encourage you to reach out and get some early help. Asking about immigration status can be harassment, not just using that information to intimidate someone, which is definitely also illegal, but even just simply asking about it can be harassment. And I also want to flag, again, there are so many different forms it could take, but one that I did want to highlight too was interfering or retaliating against tenants for speaking up and for speaking to each other. Tenants are allowed to share with each other what their rent is, what the landlord said about their repairs, anything you want, pretty much. And you're allowed to share with each other what your rights are. And you're even allowed to get together and form a tenants association, which is kind of like a union for tenants. So that is protected, all protected, and the landlord should never be trying to punish anyone or get in the way of those efforts. So any of these things could be harassment, right, and more. But it is important to know that the intention does matter in terms of whether it's harassment. Like, for example, maybe you can imagine a situation where a repair takes a long time and it's not because the landlord is trying to harass the tenant, or a service is taken away or access to a facility is taken away, and it's not because the landlord is trying to harass a specific tenant, it's just some issue with that facility or that service, right? So just to mention that, showing that it's sort of targeted harassment is helpful. What you can do, there are several options when it comes to harassment. So as I mentioned, they've increased the fines and criminal penalties that landlords can face for harassing. The tenant also has the right to sue the landlord for harassment. You can take it into your own hands and sue for damages. And if the landlord does try to evict, harassment is also a defense against an eviction. If you've been being harassed to be pushed out, or such things, right? You can bring that up as a legal defense against an eviction. I believe this is the last thing I want to share, the last form of protection. And this is actually a state law. So this applies not only in LA County, but throughout California. It's called the Tenant Protection Act. And it basically gives some amount of rent control to areas and homes that don't already have it from their city. So if you're in the city of LA, there's a decent chance that you have rent control from the city. And if that's the case, that is stronger than this. So you definitely want to look into that and see if you have that. But if you don't, if you live in another city, or if you just live in a home that didn't qualify for rent control, right? You may still have protections from the Tenant Protection Act. So this applies to multifamily, meaning like apartments or anything, 3 units or up, we can say, that is over 15 years old. So basically it doesn't apply to new construction, but it applies to bigger properties over 15 years old. If the property has 2 units, like a duplex, it's also covered as long as the owner doesn't live in the other half of the duplex. So if it's a duplex and both parties are tenants or they're just neighbors unrelated, that would be covered. And a house or a condo or some other single unit home is only covered if it is owned by a corporation. I saw we had someone from Inglewood with us. In Inglewood, one of the big corporations that owns a lot of houses, a lot of homes is Wedgwood. There's also Invitation Homes, Graystar. Some of these companies, if you pay your rent to a big company like that, good chance that it's covered by the Tenant Protection Act. I know that's a lot of different criteria, a lot of ifs, ands, or buts. We are always here to help you figure out what applies to you. We do not expect you to like memorize these things, but hopefully having the information is still helpful. So if you are covered, what do you get, right? What you get is, first of all, a maximum, a cap, a limit on rent increases every year. That's important. For LA County, the maximum rent increase right now for these homes is 8.6%. But as of August 1st, that's when they give us the new yearly number. So after August 1st, it is going to increase to 10%. That's the highest it will ever go under the Tenant Protection Act, 10%. And that's again for the year, maximum rent increase. The other thing that these protections give is some protections against evictions. It's called just cause for evictions. And just cause just means a fair or valid reason for the eviction. So the landlord has to state a reason, and it has to be one of the valid reasons. There's about a dozen of them. I'm not going to go into all of them, but many of them are what we call at-fault evictions, where the tenant did do something that's prompting the landlord to evict, like maybe breaking the lease, damaging the property, causing a threat to other people's health or safety, or perhaps tolerating criminal activity on the property can also be a valid, regardless of the COVID protections and other such protections. Generally, these are going to be valid reasons for eviction, generally. I will also say that generally, some just causes are also not the fault of the tenant, right? There may be reasons that are not the fault of the tenant that the landlord is still allowed to evict, but not while we have our emergency temporary, still have a defense against no fault evictions. All right, so as promised, I'm just going to end by landing again on Stay Housed LA. I just really want to emphasize the Housing Rights Center. We can answer so many questions for you. We can help with a lot of different things. We can help you to get a disability-related accommodation in your home, for example. But if you receive an eviction notice or a notice from your landlord, at that point, what you really want is a lawyer. So before you come to HRC, do not pass go straight to Stay Housed LA and see if you can talk to an attorney. And especially if they can help you to respond to the eviction. If, let's say that you receive a notice and you call and you don't hear back in time, right? You can also respond to the eviction notice yourself by filling out that form called the answer. And you can do that by going to the self-help center at the courthouse. The self-help center, they have staff there who can help with some forms like the answer form and help you to fill it out. Okay, so even if you don't hear back from legal aid in time, you still want to make sure you get that form in, right? So get it in and then continue to wait for Stay Housed to be able to help you further. And that is it. That's all that I had to share today. Sorry, I'm just seeing my face now and seeing how dark it is in my room. My apologies. I'll turn the light on in a second. But here is our contact information for the Housing Rights Center. If you do have, you want to follow up and ask a question privately, our counseling is confidential. We can also spend a little more time with you. And if you have some documents, we can look at those too. So if that's what you're looking for, please do go ahead and give us a call or send us an email. You can also make a Zoom appointment on our website. They fill up very fast, I will say. And I'm also happy to take some questions now. Are there any parts that, yes, go ahead, please. Cynthia, go ahead. Oh, can you unmute yourself? Do you see like a microphone button? Do you see a toolbar with any kind of buttons on it? Okay, it should be either at the top or the bottom of your screen if you have the Zoom window open. Possibly, I wonder, Lisa, if you're able to.
Yeah, it's Cynthia, right?
Yes.
Okay, I just asked her to unmute. I'm
Okay,
waiting
perfect.
to see.
So Cynthia, you should get a pop-up that you can click to unmute. No? Okay. Well, maybe you can ask him.
Okay, there I am.
Hi. Okay, hi, great.
I couldn't find it. Okay. Oh, what I wanted to make a point that many of these self-help centers have been closed. I know they were closed during the pandemic. Now, maybe they've opened, but their hours are so, their hours are different, So if you're working, it's kind of hard to, even before the pandemic, if you're working, they would stay open until I think around 4.
Yeah.
But now it's just iffy.
Yeah, I understand.
So what do we do in that case?
It is possible to fill it out yourself. And if you're not able to get in touch with anybody who can help you, then definitely just at least get it in. Because if you miss it, if you don't turn it in, it's very easy for the court and the landlord to basically say, well, they didn't respond. I guess they don't care. They don't want to talk about it. They don't want to be part of the process. So I guess we'll just go ahead with the eviction. You don't want that. You want to get the form in. So yeah, so if you have to fill it out yourself, you can do that too. I also think that the court's website has some pretty good instructions and resources. I'll put it in the chat. It's just courts.ca.gov. And they have a page about the eviction process and they go through it step by step. And I think it's a pretty good guide. And they have the form available to download there too. But basically, it's not a super complicated form. I always want people to have a lawyer if possible, but it basically will just say, is there any reason that you think you shouldn't be evicted? Do you have a defense that you want to share? And you can sort of check the box and say, yes, I do.
Mm-hmm. Yeah, I'm not really concerned about myself about that happening, but it's always nice to know because, the condominium complex that I live in, one of the other tenants and a neighbor was being seriously harassed. And she simply did not know what to do. She called Housing Rights Center. And I think you guys spoke with her. Someone spoke with her. And she felt so much better after speaking.
Oh, good.
To the Housing Rights Center. However, she did finally move. She just moved at the end of last month. It was very sad though, very sad because she truly was being harassed. And then there was also there was a form of racism that the landlord was
Yeah.
Yeah, it was sad, but anyhow,
Yeah, and that is unfortunately very common. I know we're going to have another workshop on fair housing, which is about discrimination and preventing and
right.
enforcing anti-discrimination laws. So we'll talk about it more. But I did just want to mention, since you experienced this and brought it up, that race is one of the is the actually the top form of or basis for discrimination that how fair housing groups get every single year. It still remains at the top.
Wow.
Really big problem. Yeah. And actually, I'm sorry, but Lisa, I wonder if we could actually stop recording for the questions, just so that people might have a little more freedom to share things
Yeah.
that might be sensitive.
Yeah, sorry about that.
No, no problem at all.
Okay.